Herbert. I'm the New York City LERA chapter president, and I'm a distinguished lecturer at Hunter College. We welcome you today to, this will be our last chapter meeting before the summer. I'd like to start with inviting our chapter's Vice President Oriana and Secretary Suda to introduce themselves. Oriana?
Yes, hi all, my name is Oriana Blake. I am currently the Vice President of New York City's chapter of LERA, and will be the president for the next term, and am an Assistant General Counsel at Physician Affiliate York, where I do labor work, and support New York City Health and Hospitals.
My name is Siddip Mukherjee. I am the LERA secretary this year and will be the vice president for next year. And I am in-house counsel at Local 1199 SEIU, United Healthcare Workers East. And I'll push it over to Dean.
Well, I just wanted to say that over the summer, I'm going to be rotating off the chapter leadership. And I just want to thank Oriana and Sudeep for the great pleasure of collaborating with them, if not conspiring, over the past year and seeking to expand the scope and reach of our chapter. But we're extremely pleased to announce that Arbitrator Dean Burrell will become the chapter's new secretary starting in the fall. Dean has extensive experience as a former leader of other LERA chapters and bar associations over his distinguished career. Dean, do you want to give a little introduction to yourself?
Certainly, I'm a labor and employment arbitrator, mediator, based in Morristown, New Jersey, even though I'm on tri-state. I am from Queens, so I do have my 5 bona fides. In terms of AAA, I'm on labor, employment, and the MEPA panel. And this is my 5th LERA chapter. Kind of losing count. I was president of the Arizona chapter, or as I like to say, all 5 of us, and active also in Jersey. So look forward to being of assistance. Thank you.
It's fair to say that 5 LERA chapters is not like the same thing as having 5 Oscars, but we thank you for joining us. So our LERA chapter would like to express our appreciation to the American Arbitration Association and its staff for the use of their offices, and to LERA national staff, Emily Smith and Bernadette Dearman, for their tireless help on behalf of our chapter. We also want to thank Epstein, Becker, and Green for being the CLE service provider. If you've not already done so, we strongly encourage you to join National LERA as well as join our chapter. Next year, National LERA will be holding its 75th annual conference in New York on June 26th to the 30th at New York Hilton. Your active participation will help LERA and this chapter to broaden its horizons, including subjects of our programming. The topic of tonight's meeting is mental health legal issues in the post-pandemic workplace. This is a subject of great importance for individual employees, their families, their employers, and their unions. In my experience as a lawyer, I have participated in cases involving diagnosed, undiagnosed, and misdiagnosed mental illness in the workplace. It is likely the pandemic will lead to an increased number of such cases. You should have received an email containing the presentation materials, evaluation form, and CLE affirmation form if you are attending by Zoom. Please let me know if you did not receive the email so we can send these materials to you. For those virtual attendees requiring CLE credit, please record all attendance verification codes that I will be announcing during the program on the affirmation form that was provided. Please complete and return the form as indicated at the bottom of the form after the end of the program. Send the form to, as indicated, to the address at Epstein, Becker, and Green. As a courtesy, as I mentioned before, please mute yourself during the presentation. Let me now introduce our panelists. Jennifer Monthie is the Legal Director of Disability Rights, New York. She practices in the area of education, community integration, and civil rights of individuals with disability. She's a founding member and current chairperson of the New York State Special Education Task Force, which fosters collaboration between schools, parents, and advocates on special education. Second speaker is Howie Wexler. Howie is a partner with Seyfarth Shaw and serves as co-lead of Seyfarth's New York City Labor and Employment Law Department, and is also co-chair of Seyfarth's New Jersey Labor and Employment Law Practice. Howie's practice includes representation of management in employment litigation matters before state, federal courts, as well as before federal and state agencies. Oriana Vigliotti is a senior counsel in the New York State United Teachers Office of General Counsel in New York City. Prior to joining NYSED, Oriana was an associate at Cohen, Weiss and Simon, and representing local and international unions and affiliated pension and benefit plans. Her practice focuses on collective bargaining and affirmative and defense litigation and appeals to NYSED, its affiliates, and their members in federal and state court and administrative forums. So the speakers have created jointly collaborated on a PowerPoint, which I'm now going to be bringing up, and we're then going to start with Jennifer as we get this set up. Okay, great. So Jennifer, do you want to begin?
Sure. Welcome, everybody. We wanted to, as speakers, to start with just a note on language. I think is important when we think about mental health in the workforce. So language can be inclusive. It can also be alienating and divisive. And so we want you to be aware that many organizations have guides about the use of language in referring to people with disabilities. The American Medical Association even has a guide, and what they put in their preference is that they're not providing a list of correct terms, as that would be impossible to sort of achieve. But again, their guide is really about providing guidance on equity focused or person-centered or person-first language. So be aware that in the disability community, person-first language is often a preferred way of referring to individuals with disabilities, so that their identity is first and their disability is second. But many people within that same community might also prefer to be identified as identity, their disability first. So for example, instead of referring to a person with autism, some people prefer individually to be referred to as an autistic person. What we would advise is that you ask the person how they would like to be referred to, as we do in any other population of people. Please also note that many of the laws that we're going to refer to have undergone some modernization of the use of language. Actually, the Americans with Disabilities Act, which we're going to focus on, was one of the first laws that really adopted the concept of person-first language in the 1990s. Before that, many of the laws that protected the civil rights of people with disabilities focused on identity-first language and used terms today that the community would find to be archaic. You can go to the next slide. So now that we, I addressed that we're going to use person-first language in this presentation, the mental health crisis is a term that I think many people are sort of experiencing now in the post-pandemic world. According to the National Institute of Mental Health, mental illness is very common in the United States, with more than 1 in 5 US adults identifying as having a mental illness. That includes, the term mental illness includes many different conditions that vary in the degree or the severity. They range from something that might be considered to be mild to moderate to severe. But generally, there are 2 broad categories that the Institute, the National Institute recognized, which is any mental illness and serious mental illness. And the reason why this is important is that eligibility for protections might depend on which broad category a person falls within. Go to the next slide. So any mental illness is really defined as a mental, behavioral, or emotional disorder, and it can range from impact to no impact on the person's life to mild to moderate, even to severe. The term serious mental illness, which is found in several of our federal laws, has the same beginning to it, but it results in a serious functional impairment, which, and this is the key term, substantially interferes with or limits 1 or more major life activities. As you consider the laws that we talk about later on in the presentation, you will see that many of the protections that someone might find under these laws comes from that definition of substantially interferes with 1 or more major life activities. Next slide. To begin, I think it's good to set a foundation of where we are in terms of the prevalence. As I said at the beginning, the existence of mental illness in our population is common, but the statistics are growing. So in 2021, 22.8% of the US population identified as having a mental illness. the identification is more prevalent in females than it is males. What's I think also important to recognize is that young adults had the highest prevalence of mental illness in our population in the 2021 study, and that it was highest amongst adults who reported 2 or more races. So the intersectionality of people who identify in more than one protected class is important to recognize when you are dealing with employees in the workforce as well. Next slide. So the prevalence of serious mental illness, remember, that's the category of people who identify as having a mental illness that significantly impacts one or more major life activity. That is estimated to be 14.1 million adults from the ages of 18 and older. It is again highest among females, slightly 7% over 4%, and it is highest in young adults 18 through 25 from the same study. Next slide. So in that way, we have a growing concern. The national data that was recently been collected from the National Comorbidity Survey of Adolescent Supplement estimates that 49.5% of adolescents had a mental disorder. That is an enormous number that we're going to be reckoning with in the workforce in the coming years. And that those adolescents, 22% of them are identifying as having a severe impairment or distress. Next slide, please. So one of the things to also recognize as a practitioner in this field is that many of these terminologies of mental illness are coming from diagnoses driven from the Diagnostic and Statistical Manual of Mental Disorders, or the DSM, and this is the 5th version, DSM-5. It's a reference book on mental health that is written, edited, and reviewed by the American Psychiatric Association. It sets criteria for more than 70 disorders, and it's often used in legal advocacy or legal claims to demonstrate eligibility for the protections of the laws that we're going to talk about today. Next slide. So many of us have maybe recognized that the pandemic shined a light on the topic of mental health, particularly in the workforce, but the pandemic did not create this problem in our workforce, nor did it create the mental health crisis that we're currently facing. But it did allow more attention to it, which resulted in the Surgeon General coming forward, releasing guidelines for promoting employee mental health in the workforce. Through that guideline, 76% working in 2021 reported symptoms of anxiety or depression, and 17% reported an increase over the previous 2. This is a 17% increase over the last 2 years. According to the Surgeon General, excessive stress costs us nearly $200 billion in medical payments each year, and more than 100,000 unnecessary deaths. At work today, we are, and this is according to the Surgeon General, too unwell, too anxious, and too overwhelmed. Research that's also been conducted on employees by Mental Health America. I encourage everyone to take a look at this 2021 Mind in the Workplace report. It has an alarming mental health crisis happening in the workforce across the country during the COVID-19 pandemic, and it certainly hasn't abated since many of us have returned to work. Next slide. One thing to note is that work is actually considered one of the solutions to the concerns of mental health, that individuals who work describe it as a key in their health and contributing to their sense of purpose and well-being. So while our population is stressed and overworked and anxious, those that are put out of work are also not able to get the benefit of contributing, which also increases their deterioration of their mental health. It's important for employers to understand how to foster mental health friendly work culture, and that work cultures that foster mental health friendly environments are not just beneficial to people who identify as having mental illness or even serious mental illness, it's beneficial across the workforce for everyone. It leads to greater productivity, reduced insurance costs, and improved employee retention and morale. So I'll switch it over to Howie now.
So before we start understanding the law, let me interrupt with the first code for those who want CLE credit on Zoom. So the following is the first code, which is EBG, as in Epstein, Becker, and Green, EBG 136. That's EBG 136. Howie?
Thank you, and thank you for everyone and for having us all here today. Anytime talking about accommodation issues, post-COVID, you think back to kind of what the world looked like before. There was a case, like many others, but this is one just where I think the language, now stands out. It's a 2017 case from the Fifth Circuit, where it says, at its initial matter, there is a general consensus among courts, including ours, that regular worksite attendance is an essential function of most jobs. I think if we learned anything from the pandemic, that we've proven, or everyone has proven, that what was thought of prior to March of 2020 is not necessarily the case. And since then, there's been a lot of cases about, including one in New York, about a radiologist who was asking for remote work, and because the technology could do the work remotely, and the court held that was an issue of fact, so therefore had to go to trial. 4 years ago, I don't see that case coming out the same way. So while some of these issues are focused not just on mental health issues, I think it's just the evolving way in which, given what we've all been through, how accommodation issues come about, and what used to be thought as reasonable, or what used to thought as just per se not reasonable, has changed and is still currently changing. So we could spend hours talking about any one of these laws and any nuances within certain aspects of the law. So we're going to not do that for purposes of moving along today. I want to just go kind of have a baseline and then hopefully have a discussion, amongst us and everyone else with any questions. So, the main federal law that governs, accommodation issues is the ADA. It prohibits employers from discriminating against employees based on a disability. A protected employee either has a disability or perceived to or regarded as have one, or an associational discrimination, which we'll get to. So the ADA is the main federal law that governs, everyone in the United States. Next slide. Title I of the ADA, and there's, other titles. There's, again, a whole seminar on website accessibility, which is a different section of the ADA. But Title I makes it unlawful for an employer to deny jobs, promotions, or other benefits to employees, based on fear of stereotypes about mental illnesses. It's also unlawful for a workplace to adopt rules or procedures that disadvantage those with mental illness or other disabilities. And the key for our discussion today is that employers are obligated to provide a reasonable accommodation to enable those employees to perform the essential functions of their jobs. Next slide. The New York State human rights law is the state counterpart to the ADA. It's similar in a lot of respects, but in some respects it's different. The first, it requires all employers to provide a reasonable accommodation for people with mental health issues and other disabilities. And employers also don't have to provide accommodations that would be an undue hardship or burden. Again, this is similar to the ADA. However, a threshold issue, the ADA only applies to employers with 15 or more employees. The New York state law applies to all employers. So one employee, there's coverage under the state human rights law. So there's that threshold issue. Another issue, and we're going to get to what is a disability under these laws, but under the ADA, it has to be a mental health issue or some other issue that substantially limits a major life activity. That language is not present in the New York State or New York City law. So again, the threshold for what triggers an employer's obligation to accommodate, if you're just focusing on the ADA versus the state and city law, you're missing a very key factor. And I've seen cases where a court has said, look, under the same set of facts, under the ADA, employer, yes, you didn't violate the law. Under the state and city law, you did, because, it's an issue that a jury would have to decide based on the different standard. So again, something that just to keep in mind, especially for those who practice in this space, that just looking at the ADA or even the New York State human rights law isn't enough, because if you go then to the next slide, there's the New York City human rights law. The city law is similar in a lot of respects to the state law in terms of not having that, substantially limits language. A few years ago, the city pretty markedly changed the accommodation process under the city human rights law. And now what those of us who are familiar with these issues used to call interactive process under the city law is now called the cooperative dialogue. Is it the same thing? Is it different? It's the same thing, but it's meant to be more cooperative and emphasize, I think, the fact that it's meant to be a discussion, not someone saying this is the accommodation we're offering you. It's a cooperative, and that each side has an obligation really to bring their thoughts to the table about whether or not there's an accommodation available, what works and what doesn't work. There's also a lot of rules and regulations about what employers have to do under this law to document the accommodation or the cooperative dialogue discussion. So every accommodation, even if you're granting the employee the exact accommodation that they want, an employer under the city law has to document it. Merely not documenting, Howie Wexler, you requested this accommodation, we're giving it to you. If you grant them the accommodation, but you don't memorialize that in a written communication to the employee, that violates the law. Do I think that's something that employers stay awake at night worrying that they're going to get sued if they give someone the accommodation they want, but they didn't memorialize it? No, but I think what the city law has done, in my experience, is for those employers, both who operate in New York City and elsewhere, saying, that's a pretty good idea to memorialize this from a perspective of, putting the liability issue aside, but just to make sure there's no ambiguity. And I like to say this, I know enough to be dangerous in a lot of these issues, but I'm not a doctor. I don't know what's reasonable or what's not reasonable. I don't know if this particular accommodation, it may have worked with someone who had one mental illness, and it may not work for that same person with that same diagnosis, given that how it manifests itself. So documenting these things, going both ways, so that the professionals can weigh in is, I think, a best practice that, again, regardless of where my clients operate, is something that I stress to all of them as a best practice, to memorialize these things, to document it, because it makes sure there's nothing lost and that there's, a written document explaining exactly what was offered and what the accommodation was and why it was not granted. And if not, what other options the employer has that they could possibly offer as an accommodation. Next slide. So again, this kind of summarizes what we've been talking about. We could go off on a tangent about all the leaves that are available for people with, disabilities, which again, we could spend the whole day about, but all these show the patchwork of laws that have developed, under the state and city, are all things that employers and employees and unions, need to be aware of, because in a lot of ways, the absence of there being tremendous federal changes, state and city have tried to pick up the slack and try to help, employees with different types of leaves and the like available when they're disabled. So
I'll jump in here real quick
Yeah.
before I turn it over to you. So as an employer, it's really important, as Howie said, the federal law has remained relatively stable, although there has been some shifts, about 10, 12 years ago in that law, but the local laws and the state laws shift more rapidly. So it's really incumbent on an employer to stay up to date on these shifts in the law, particularly not just, staying in the focus of how the laws have changed for people with disabilities. But as I said at the beginning of the presentation, many people with disabilities have intersectionality with other identities, clearly, whether it's based on their race, ethnicity, gender, and many of these laws have really exploded in the last 3 years and continue to change with, I would call it even a competition between the city and the state of passing these protections on to employees. While we're going to take a deeper dive into the federal law here, it's really important that you stay up to date with the state and local laws as well.
Now we're going to move to union support for workers, and Oriana is going to talk.
So what if you're in a unionized workforce? We're going to take a step back here and not talk specifically about the law, but what can unions do and how do unions support their bargaining unit members who have disabilities such as mental health issues? Number one is negotiate for an EAP program, an employee assistance program. Almost all the unions that I work with have EAP programs that in their collective bargaining agreements are funded by management. New York State has a great EAP program, and the way that, if you're negotiating, you can sell it by saying it enhances employee well-being, it increases productivity, and it can improve morale in the workplace. Again, it's funded by the employer generally in the collective bargaining agreements, and they can provide mental health supports, they can provide counseling, they can provide drug and alcohol counseling. So EAP programs, I know we have them at my job. We have an EAP program. I work with teachers, and a lot of teachers, it's extremely stressful. Teachers come and sometimes they present with mental health issues, and they are often turned to the EAP program. It's confidential, and it's a really good place for people to feel supported, and that's something that unions can do. Unions can help clarify options. So when you are a person who is having mental health issues and you are at work, your employer is how you have your livelihood. They pay you. Your union is there. They are your brothers and sisters. They're there to support you and to help you through the process. The union can help clarify the options. They can be the go-between with the employer, helping workers understand the options available to them in the accommodation process, which can be overwhelming, especially if you're suffering from a mental health issue. Obviously, the unions advocate and support. They can help ensure that the accommodation plans are focused on worker success, including when mental health needs to be taken into account, and the union can support individual needs. I mean, we talked about this when we were preparing, that people sometimes feel completely alone. They're alone perhaps in their personal life, but at work and with their union, they can feel supported, they can feel heard. And so just knowing that that's available can help people. Obviously, the union is there to help, police and respect the CBA, the collective bargaining agreement. The union has the in-depth knowledge to ensure that the accommodation process respects the collective bargaining agreement. We'll get into that a little bit more when we talk about the accommodations process, but that's a big issue there, the respecting the collective bargaining agreement and following up. Periodically checking in with the worker and the employer to help ensure that the accommodation is working and making suggestions if adjustments are needed. Again, it's a way for the people to feel supported, to know that they're heard, and the union can help with that in a more safe space. I mean, your employer, it's a little scary. They're the ones who, you rely on to have money to make the mortgage payments. And so knowing that you have this entity, these people that are supporting you can be really, really helpful. Again, this is more of just a summary. Unions negotiate. They can negotiate for mental health support, not just in EAP, and promote social support among the members. Again, I think that could be really helpful to know that you're not alone, acting collectively. Again, this idea that you're part of a whole and serving as a source of information. I mean, that to me is probably the most important thing. I see we have our members that come, and it's hard to navigate this system, especially I work for NYSET primarily with the UFT. It's a huge entity, the DOE. There's lots of supports, but it can be really scary, and it can be hard to figure out how to go through this process, what forms you need to fill out, who you need to talk to. And so the union is a really, really good source of information.
So before you jump into the law, I just wanted to revisit the idea of EAP, not just from a union perspective, but from an employee perspective. It's often a benefit that employers have that employees are not aware of until the employer redirects them to that. So something they may hear about on onboarding or on that yearly membership health benefit, re-up every year, but they don't think about that when they're having a crisis, whether in their personal life, not directly impacting them, but maybe a family member or for themselves. So before we get into sort of the specifics of what happens when an employee sort of comes to you as an employer and asks for something, things that employers should think about proactively is how to promote the benefits to their employees before a crisis happens. And many of the larger companies, both on the for-profit side, but not-for-profit is also contemplating this, is how to create a culture where we're having these collective discussions and thinking about mental health and well-being in the workforce. Many large firms, particularly in the city, are bringing on people specifically for the purpose of promoting wellness within their firms. And all employees, whether they're small or large, should really think about these concepts of proactive steps that they can take to support their workforce, help reduce the loss of workforce that happens in crises involving mental health. And EAP, even, many of them have free seminars that they allow they to bring into an employee. So it doesn't need to be specific to one employee seeking it out. There are benefits sort of there if you purchase them. So something to think about as both an employer, but also as an employee, to dive into the benefits that you may be entitled to during these periods of time.
And from the employer's perspective, with the EAP piece, I think a lot of employers, whether it's negotiated or just, have it because it's not a tremendously, usually costly benefit to offer. And I think the dividends, pay for themselves. But I think from the employer perspective, a lot of times it'll be no one utilizes it because whether it's, and not that, they mentioned it during open enrollment, but I think sometimes there's employees are a bit reluctant sometimes because they feel like, I'm being watched, or there's gonna be a report filed. So do you find that when, if you've negotiated it, or, that sometimes there's a reluctance on behalf of employees to avail themselves of it for that reason?
Yes, but I think that we really try to stress the confidentiality of the program, that no one needs to know that, but yes, it is hard. And so I think talking about it more, bringing people in, we have speaker series, and taking away the stigma of going to the EAP. Because when I think about it, just as a layperson, to me, I instantly think of like drug and alcohol issues, that's like, oh, you gotta go to the EAP, which is, wonderful, good thing. But I don't think that people often think of it as this encompassing thing. And I think the more you talk about it, the more you normalize it, that people will use it more. But yes, absolutely. Sometimes it is an underutilized thing and it can be so helpful.
And as an employer, you may be reluctant to sort of promote it as with a fear that it becomes an employer-driven concept. But we have found things like being able to find spokespersons within your organization that have used it. For example, it doesn't just need to be mental health. We've had employees just in our own organizations used it to find childcare. So if you promote it for the series of bringing in somebody to speak, often does lead to people using it, and often does lead to the employees communicating with the employees about the benefit of it. But I think another thing that employers need to be aware of is if the EAP is falling down for the employee, it's not working for the employees, that you as an employer are exploring other potential EAP services. So one of the benefits during the pandemic of EAP was many people can't get access to a mental health provider for months after, whereas some of the EAP services is an immediate person to speak to, 5 sessions, 4 sessions. We were finding from some employers that promise of benefit wasn't actually there. And so you really have to be vigilant as an employer to make sure that the benefit you're providing is actually existing. So you ask your employees to try to test it out. So, I know you don't need this, but maybe if you give a call and see if it works, that gets them more involved in using the EAP services.
Okay, so we're going to take a bit of a deeper dive on, again, the ADA, which we can, for our purposes, view as the floor. For given that for those of us who practice in New York State, as well as the city, there's other laws that apply. So one thing when I was talking about the distinctions, for pregnant employees in New York City, there's a whole separate law about the accommodation process in terms of what employers can and can't ask in terms of documentation if you need an accommodation and things like that. So again, it depends on what type of employee and what's the accommodation, but paying attention to those local issues is very important. So as a broad level, like we had said, the ADA prohibits discrimination and harassment against qualified individuals with a disability and requires employers to offer reasonable accommodations to those qualified individuals to perform the essential functions of their job, so long as it doesn't create an undue hardship. And we're going to take a deeper dive into those topics shortly. It also protects individuals who have a record of a disability. So that's someone who may have previously had a disability and now if it was a mental health disability, they had that and they're no longer diagnosed. However, they may be viewed as a certain way by the employer of having a record of one. Those individuals aren't entitled to accommodation, but they're protected from being discriminated against because of that record of disability. And someone, the same thing, regarded as disabled or associated with someone who's disabled. So if you're an employee who does not have a disability, but you have a family member or someone else who does, it's unlawful for an employer to discriminate against you because you're of that associational discrimination. Next slide. So who is a qualified individual? It's someone who can perform the job with or without a reasonable an accommodation. So that means someone who maybe on their own without any accommodation can do the job, or with one that is reasonable is able to perform the essential functions of the job. And again, each of these criteria we're going to break down a bit more. Next slide. So, in terms of what is a disability under the ADA, and this is what we talked about before, it's something that substantially limits a major life activity. It may include temporary conditions, and it doesn't matter. A lot of employers think, well, if that happened away from the workplace, I don't need to address that. The person hurt themselves on the weekend. That it doesn't matter. It's not a workers' comp. It's not, we can't conflate it with that. It doesn't matter where or how the disability occurred, just that you have an employee or an applicant that has a disability, and then you're on the, you have to accommodate that. Next slide. What is an impairment? Any physiological disorder or condition, or other, that could affect one or more body systems, mental or sociological disorder, intellectual disability, organic brain syndrome, emotional or mental illness, specific learning disabilities. So, the key for all these things, it's that all these laws, the ADA including, are meant to be broad and meant to encompass a lot of different types of disabilities and impairments. So from the employer's perspective, when these cases are litigated, it's usually not whether the person is disabled is where the litigation activity is. It's on the accommodation piece and what was offered and whether it was reasonable or not. So a lot of these things, in my experience, counseling employers, we're not really having that fight. Well, it's not really a disability, or things like that. That usually is a given, and it's because as an employer and employee, you can require your employee to provide you documentation regarding the the disability, so that you have that proof, but also so that what type of accommodation they need. Next slide. Okay, so what is an essential function of the job? This is something that, again, I counsel employers about frequently, because you ask the employer, well, it's on the job description. I had a case that settled a few years ago where one of the criteria in the job description was that you needed to be able to lift up to 100 pounds. We had 14 depositions of employees who were deposed. It was a one person, was suing, and we deposed a good number of people, and not one of them said they ever lifted anything close to 100 pounds, nor were they ever required to lift anything under 100. So the fact that as an employer, we had that in our job description under the essential functions category was something that the court very quickly said, that's not an essential function. So, it's a plug for employers to always, update your job descriptions, especially when, you're looking for talent, to make sure it actually reflects the nature of the job. But also just listing and taking the approach of just dumping everything in a job description so that you have reserve the right to say it's essential, that is not going to work. Courts are pretty sophisticated right now and will not look at that, solely to determine what's essential function or not. Doesn't mean that you shouldn't list things that are, and it doesn't have to encompass everything, but you can't just take the kitchen sink approach to it. So, what is essential? If it's the reason a job exists is to perform that function, it's essential. It's a limited number of employees who can perform that function, to perform the job. It's not something that you can have someone else cover that task. I had a case where someone was a social worker, and they had to meet for intake interviews, write notes, and this was 10, 15 years ago, and then be able to interface with various other people based on how that interview went. And the person had issues, both hearing issues and also being able to bend and put the information in the file cabinets and things like that. And we were able to work with the employer. And initially the employer's perspective was we would have to have a second person do this job and basically shadow them. And we were able to work through with the employee and the employer and find an accommodation for that person, where initially my client's thought was, this is an undue burden. We have to hire a second person, but it's not. You're able to find things, especially in 2023 with the technology where you can have a radiologist who could perform the work remotely. There's lots of different ways. So again, this is a function of why this is ever evolving, because the way in which employers can accommodate people changes on a daily, weekly, monthly basis, given the changes in what we're seeing. And I'm sure there's some way or some article about how AI is going to be impacting that as well. But there's all sorts of ways that those type of things can be done, and it's not necessarily going to infringe upon an employer's ability to have that person do the job. Next slide. So these are just a list of a non-exhaustive list of factors to consider to determine if something is an essential job function. An employer's judgment does have some weight. I don't want to say that it doesn't matter, but again, it's going to be peeling back and looking at what actually the job is. If something takes 10 minutes out of a work hour, work shift of 8 hours to do, it's likely not essential. If it's something that you don't have to do during the workday, again, it's likely not essential. So again, it's not a magic. You can plug something in and whether it's essential or not, but there are certain things to look at, both as an employer and employee, in order to determine whether or not something is an essential function of the job. Again, the basic one that we talked about earlier was being there. Used to always thought that's, you got to be there. That notion has been dispelled for some positions, not everybody. But again, showing how these things can change. Next slide. What is a reasonable accommodation? It's something that removes a barrier or restriction for someone with a disability. So for instance, I know in our office, there was 10, 15 years ago, certain people had the standing desk because they had a back problem, they need to stand. Now, all the desks we get are automatically built in with the standing ability because that's an easy fix and something that's evolving in the workplace. So that is an accommodation that enabled someone to perform their job, given that lawyers, we sit a lot, and being able to walk around and do things like that. So it's, it removes a barrier that exists because of that person's disability. There's a lot of cases about people with light sensitivities and changing lights or changing computer monitors or screens. I had one of those, somewhat recently where we were able to relocate the person because where they were sitting really neurologically it was impossible for them to work in the location where they were working because of their sensitivities to light. So, a reasonable accommodation removes those barriers without eliminating one of those essential functions of the job. And if at any point any of the other panelists want to chime in, please do so. But next slide. So again, what the barriers really could include anything: physical obstacles, modes of communication. Again, that's an issue of, again, remote work solves a lot of that, procedures or rules or job duties or, restructuring. Having someone do some of those tasks that are a 5-minute task in an 8-hour day, that's not an essential function that you could have somebody else do. Or, we're only going to have you do light duty work. There's a way for us to only assign you to these tasks in a day. If we bundle them together, you're still performing the essential functions of your job, but we can remove some of the more challenging or some of the tasks that pose a problem to you. So they really could include a host of things. And again, what are examples of reasonable accommodations? It's a no one size fit all. And that's the key to these laws, is that, just because the accommodation worked for one person with one disability, it's critical mistake for an employer to say, well, that is, you have to accept that because that's what we offered with somebody else. Or it didn't work for one person in the position, so we're not even going to offer it to you without seeing what that person's ability to do the job is. So making facilities more accessible, if someone works on the 4th floor and you can put them on the ground floor. We talked about the light type situations, reassigning or eliminating those essential functions of the job. So on the rare, once in a blue moon, someone may need to lift a 75-pound item where no one does it usually, reassigning that, no issue. Modifying work schedules, so changing someone's shifts, providing a modified equipment or device that enables them to perform the job. Again, the standing desk is a simple example of one of those. Modifying certain policies so that it doesn't, they don't apply to them, or giving them a reprieve from some certain policies. readers or interpreters, telecommuting, again, a big one, and then reassignment to a vacant position. As an employer, you're not obligated to create a job title or create a new position for someone. However, if there's a position that's vacant, it could be something that you offer to someone as an accommodation. It doesn't have to be forever, but it's something that, especially if it's a short-term disability, it may be a solution that's workable for you.
And I'll just jump in here. I mean, one of the things that I think employers make as a mistake is a response to an employee for an accommodation that if we offered this to you, we would have to offer this to everyone. And a perception that it would impact the workforce, right, of having to justify the accommodation with it to other peers or other people within an organization. I think it has the opposite effect. You know, I think employers should be less concerned with that other employees will interpret accommodations as more favorable treatment. And instead, the way employees interpret it is, if I need an accommodation one day, my employer is available to give me that accommodation. One, the law doesn't contemplate them considering how it might impact another employee besides the one seeking the accommodation. But two, they should contemplate how, and this goes back to the statement about making an environment more friendly to individuals with disabilities actually promotes the wellness of everyone within the organization. That offering accommodations is, say, a good faith representation to the workforce that you know how to follow the law and that you're going to be available when an employee needs an accommodation. And many employees understand that their status as a person who might need an accommodation one day is in flux, and they may be seeking such an accommodation from their employer in the future as well.
So what if your workplace is organized and you have a collective bargaining agreement that controls the working, the working conditions of the employees? Then in those instances, I hate to rain on everybody's parade, but when I was reading the cases, oftentimes, and this will, certainly the unions will work with the employees. They want what is best for both the bargaining unit members and the individual employees. But let's say the accommodation is going to mess around with like the seniority list, that the accommodation that is sought or that would be a reasonable accommodation would be telework, and that has, for whatever, that's, you get to telework pursuant to the seniority list. What if you need to skip on the seniority list? What happens then? Obviously, number one, the unions and the employer will work together to try to come to a reasonable accommodation that will work within the strictures of the collective bargaining agreement. But in general, and you're probably familiar, there's the Supreme Court case, US Airways versus Barnett, that basically says the CBA in almost all circumstances is going to control and prevail. And if the employer can't offer an accommodation that works within the collective bargaining agreement, then the accommodation is not reasonable. The employer doesn't have to do it without more. I mean, the cases come up often with seniority lists. That's, the cases that I was reading, that's the most usual fact pattern that comes up. And it's not that it can't be reasonable if it is sort of extra collective bargaining agreement, but the plaintiff in these cases would then have to show something else, like the employer never follows the seniority list, or the employer often gives this accommodation, it has been given to others. So it's not that the collective bargaining agreement can be a roadblock, but the union does have an obligation to its membership as a whole. And so that will, when this comes up, hopefully there's good communication between the employer and the union and the employee in order to help everybody come up with a reasonable accommodation. But if you're in a unionized workforce, you do need to be mindful of the collective bargaining agreement because and the union will certainly be mindful of it.
In the chat, someone pointed out the value of the Job Accommodation Network as a great resource for reasonable accommodations. Wondering if the panelists want to discuss other resources.
Well, at the end of the slide, we do have the resources, and that one is linked. I think it's in the second to the last slide that we have in terms of what type of accommodations might be reasonable. But whoever put the comment in is spot on. if you're an individual with a disability yourself and you want to think about what the array of accommodations that might be available to you, that resource actually does provide sort of a list of potential accommodations, and does provide great resources to both employers and employees on the request process and sample letters and responses and policies. So yes, I highly encourage looking at that site.
We're going to talk about what, in generally, what's not reasonable, but I'm just curious, what are the classic kinds of accommodations that people with a diagnosed mental illness may be able to ask for?
I don't know if there's necessarily classic, but you would think you could think about the use of time. So like a shorter work day or work week is an accommodation for a period of time. So oftentimes if you're maybe seeing a mental health provider and they say, okay, you're typically 40 hours a week, but I want you to work no more than 25 hours in a week or 24 hours in the week. You could see a reduction of the work number of hours for a period of time. Leave is often another thing that you might consider for a person who's in an acute crisis, and being able to maintain the ability to come back to work after an extended leave. There's also remote work is a possibility depending on how much it involves maybe anxiety or coming into the workforce. But there's also, there's a lot of things. It can be just the structure of the work location, right? So maybe it is in a highly stressful sort of work office and there is an alternative work location that has maybe less interaction with the public, depending on what type of job it is, or less interaction with coworkers. And it really can be anything. I've had work locations change because there's a scent in the office and it's like reducing the scent reduces the anxiety. So I don't think that there's necessarily ever, as you were saying earlier, one type of accommodation that fits all. I think the important factor is to really, it's a fact-based exploration. And even more than, we're talking about federal law, all of the laws are really trying to emphasize, particularly after the ADA amendment was passed, the idea of engaging in this fact-based discovery of what an accommodation could be and being less focused on prove to me that you qualify for these protections. And that's really the focus, is that presumably the employer and the employee know the job best and could know ways in which you can ensure that that employee could produce the outcome, the work that the employer needs to produce. And there is, one of the things that I hope people take away from this is, as an employer, is this is not a benevolent act. An employee, you've hired them for a reason. They provide some type of service to you as an employer, and you want to maintain them as an employee because the loss of them and the replacement of them is a resource-driven exercise for you as an employee. You've got to train somebody else to come into the job. So accommodating them to deliver the essential functions of the job is a benefit to the employer. And so when you're thinking about that interactive process, that's the approach you should take, is I want to maintain this employee because they are doing something for me as an employer that's beneficial. And if they stop doing that, it really is going to be more harmful to me. And even if that means I only get them for a quarter of the amount of time for the next 8 weeks, it's better than the resources it takes for me to retrain somebody to come into this job and perform this job. And that type of culture leads to more dedication in your workforce to working for you as an employer.
And one thing in terms of, the accommodation that I'm seeing more of, and I know my clients are as well, as, with mental health issues and emotional support animals. That's something that has become more prevalent, especially post-pandemic. And it's an interesting story. I have a client where their corporate headquarters are in Chicago, and they had ways that they started to bring them back to the office. They had requests from employees, to bring their emotional support animal, and they honored it. And they, and then they started to have issues with people who were saying, I have allergies. So make a long story short, they had less space than they had initially. And now they've opened it up where they have a certain day each week where people are allowed to, if they want to bring their animal with them, because even if you're not disabled, but people have their pandemic puppies and their pandemic pets that they bring with them, and it's helped bring that, it's impacted the office in a positive way. So I think it's a sign of how these accommodation discussions for overall wellness, especially as every employer I'm dealing with is struggling with, including my own firm, bringing people back. So I think, looking at the ways in which we've accommodated people and expanding upon that is a way to, again, help increase inclusivity in the office and, help overall wellness and well-being.
That is so wonderful. And I think that your firm should have everyone bring their pandemic puppies.
Yeah.
That
So-
sounds great.
You want to talk about what's not reasonable, generally not reasonable?
Yeah, I mean, I think briefly I'll touch upon this because, again, it's something we talked about, eliminating essential functions of the job, creating a job where none exists. If you have a person's not able to work during certain hours and you don't run during off hours, you're not required to create a shift where none exists or create business where none exists. Lowering standards of performance, it's one thing to eliminate an essential function, but in order, if someone has to meet a certain threshold or target for performing their job safely and be able, then you don't have to eliminate, that or lower, again, production. So there's no, one size fits all, we've been saying, but it's meant to be a discussion because if I found, for the most part, you may not be able to offer the precise accommodation the employee wants, but there's likely some way to figure out something that if everyone's approaching it with good faith, there's some path that could be found. And a leave of absence is always an accommodation as well. It may not be the preferred accommodation that an employee wants or even the employer wants, but that's something that is on the table as well, especially if it's something that is of a short duration.
Well, and let's not forget, don't violate the collective bargaining agreement.
Yes.
That's,
And
but,
one of the-
and include the union in the discussion. The
Yes.
Union should be there with the employee. You don't want to run the risk of that you're directly dealing with the employee if they're represented. So you want to make sure that it's an inclusive conversation.
Yeah, and I just briefly, I have a client where we're negotiating the first contract. I'm going back there Thursday for our 44th and 45th bargaining sessions. But we have one thing that we've developed a very good relationship with the union, despite not having a contract yet, is dealing with accommodation issues where we've been able to have that discussion, and it's been helpful to us to have the union there as an advocate to work with the employees and explain where we're coming from, because safety is an issue. There's a production facility, and the union wants the coworkers to be able to perform the work safely as well, because they don't want to endanger the other members. So it's been helpful to have them, that it's not just us saying no, it's us saying no, but explaining where our reasoning is coming from, and the union has been helping that because the relationship they have. So again, utilizing that is exactly right.
So in your example, you mentioned a radiologist, and I work in healthcare. And as you know, hospitals in New York City are short-staffed, and the priority is patient care, running a 24/7 operation. How do you deal with and or advise on surgeons who don't want to perform surgery and practitioners and doctors who just don't want to perform what is deemed an essential function? We struggle with that almost on a daily basis. And while we are considering and the New York City human rights law, we are hitting a wall. And I just want to know, what is your sort of take on that?
Yeah, I mean, I think in those type of accommodation issues, it's tough. I mean, maybe 20 years from now, I mean, I know there's some ways you can perform surgery and not be in the same room, cyberknife and all these things, I've seen it. But I think it's a slippery slope. And I think it's difficult in those type of, performing surgery. You may not need to be in the room, but what happens if something goes wrong? I mean, I would like to know if I'm having a procedure done, there's someone there, not in a room 100 miles away, but technology, it's changing. So the radiologist or an X-ray technician who may not need to be in the room and can, you could tell the individual, put the vest on here, and you could, so things like that. But I think for some of those positions, it's very hard to, if I were, from the employer's perspective, I understand where you're coming from, and I would have a hard time trying to justify to my client, yeah, this is the accommodation you have to offer, not performing this, because I don't know what the solution would be. I mean, as technology evolves, there are certain things that may loosen that, but I don't, for certain of those things, I think it's a tough one to think of an accommodation that'll work.
With respect to mental illness and undue hardship, I noticed in your slide, you talked this reference to negative impact on morale and employees. When did you want to just discuss the question of undue hardship when it comes to mental illness
Sure.
involving behavior issues that may have arisen?
Yeah, I mean, I think, sometimes the way in which, someone's manifesting their, a mental health issue, they may not know of it, or they may know of it, but they think they don't want to make a big deal out of it. So they're dealing with these things and it's impacting the workplace, and it makes it a toxic environment. So I think, for an employer's perspective, and it's something that we talked about when we were planning, and I, want to get into it now, is there's no magic form or magic word an employee has to say or raise your hand to say, I need to commence the cooperative dialogue discussion right now because this is what's going on. As an employer, you have to have your eyes open, your ears open. And if you're seeing something that, Howie's been working here for 20 years and get along with everybody, and then for the past 6 months, I'm getting complaints about him left and right, that he's being, speaking in a certain way to customers, to clients, to his coworkers, the answer isn't just, well, Howie hasn't said anything to us that why he's happening. So, I mean, we're just going to start writing him up for it. If you have signs that there's something going on, it doesn't mean bringing the employee in and saying, you have a mental illness. It's just starting that conversation and what's going on. And then using that as, is there anything we could offer you or any problems you're having at the workplace to start those conversations? Because the law requires that, you, again, approach it from that good faith perspective that if you see something, you have to act upon it. You have to engage in that process, and it's not, the onus isn't on an employee to specifically say, I need to start the process. And I know employers, you often struggle with, hey, I don't want to, it's a landmine, it's that third rail by accusing someone, but there's a way to do it that's not, again, the third degree interrogation. It's just saying, if this is out of character for someone, just from good, organizational behavior, HR perspective, you want to explore and then see where there's a path.
So how do you-
Yeah, and certainly I would say that, and I say this, I advise our clients of this frequently, having a disability and having the manifestation of your disability being something that is, yelling at somebody else or threatening to somebody else doesn't mean that you're not accountable for your behavior. You are accountable even as a person with a disability for your behavior. But that doesn't mean the employer, and it doesn't mean the employer can't address the accountability of that behavior. But it is, what I advise people to do, and whether you're a coworker or whether you're acting as the employer, observe the behavior. Observable behavior reflected back to an employee in crisis can be an important way to start the discussion. I'm noticing this thing that you're doing that you weren't doing before. It doesn't have to begin with a dialogue of, you must have this mental illness, or you might be in some mental health crisis. I'm just noticing that you don't seem, you're coming into work, your clothes are disheveled, you're late, you're getting into arguments. These are the things that I've observed happen. What's going on? How can we support you? What help do you need? And one of the things that we were talking about when we were preparing for this is the mental health crisis also includes a crisis of the large numbers of suicides that are happening in our population now. And a lot of the research around it directs people when they're in crisis, that people around them ask them if they are having these thoughts, actually open the dialogue and have a conversation with them, because not acknowledging it is a reinforcement to the person in that crisis that they are not cared for, that no one cares about them. So observing the behavior is actually the most humane thing that you can do to that person during that period of time, instead of ignoring the behavior. Things like hygiene, things like a significant change in them as an employee in terms of productivity, a significant change in their interaction with their peers. These are things to address very early on in the process, because if you address them early on, you may be able to get an accommodation in place to maintain them as an employee versus waiting until sort of the last straw and you're dealing with them on a termination basis.
Just going back to the undue hardship. What's the effect if behavior becomes, where it becomes clear that behavior is related to some kind of medical diagnosis? What's the relationship of the other workers, their reaction to having someone going back to work, and the employer's perspective about undue hardship in that context.
Yeah, I think it's, from an employer's perspective, it becomes tricky. I mean, if there are people who have been, the victim of that behavior, and now the person being brought back, or, you're always wrestling with how much to disclose. But I think it's, letting the employees know that, we've heard you, you came to HR, you complained that this person's been berating you or the issue, and we've addressed it, and, thank you for bringing it to our attention, and trying to, use that as an opportunity to impress upon those employees that, they would be supported, just like, we're supporting this individual. And that, we may have made changes to try to address both, concerns. So I think that's where the not heavy-handed approach, and just more having that open dialogue with your employees to try to address that. But it's something that, those issues are tricky because, they think, oh, this person, how come they're not being fired? Why a customer called and they cursed them out. I got a write-up for that. Why isn't that happening? So it's something that as an employer you have to handle, but you can't just give them the open file and say, this is why this person has this disability. But I think it's a matter of just letting them know they've been heard and, addressed, and we strive to make sure that everyone's supported in this environment and addressing it the best way that you can. But it does become an issue in these situations. And the same thing with, physical accommodations. If you're eliminating certain tasks, or, you're putting someone on light duty, a lot of times there's people that, hey, I'd like not have to deal with that. But, hopefully it's something that you built enough trust with your workforce that they understand that it's an issue that, you're doing, you have to comply with the law, and it makes sure that, if they were in the same shoes, you would treat them the same way.
Before we get questions in the room, people who are on Zoom, if you want to submit a question via chat, I will read it out as we proceed.
Yeah, a comment and a question in terms of imminent threat. I've had a situation when I was wearing a management hat where we had an individual who was diagnosed was a Desert Storm vet, and threatened to come in with a AR-15 and worked with the union, and very quietly and quickly. So that whole imminent threat thing is an important safe harbor. My question is, I see both the New York statute of city and state and the ADA, of course, use impairment. If you've eliminated major life activity from New York, how is that defined? The ADA is fairly easy because either they're impaired on a major life activity or they're not. So how is that determined under New York State and New York City law?
You're talking about eligibility as a protected.
Right.
I mean, it's broadly defined. So that's why those laws focus less on eligibility as a person with a disability. And those laws are broader than disability, right? They have many protected classes. And so, it's essentially the proofs that the employee is putting forward. Here's a doctor's note, here's a whatever it is. And then the burden triggers with the employer. So the cases are really less focused on the diagnosis and in terms of eligibility, and more on, well, what do you need and what do we have to provide? I do want to return to, I think as an employer, you have to recognize that in situations you may have two different people with two different protected class. So, if you have an employee who comes forward in a mental health crisis and creates a hostile work environment for another employee who's protected, let's say based on their race, by maybe espousing things about their opinion about that race during that mental health crisis, you now have to deal with both of those scenarios together. And the end result is not necessarily the termination of the person who has the mental health crisis that are espousing these things, but the conversations with the employee who felt directly threatened by those comments. And I do think we use the same approach, which is we're protecting your confidentiality and you expect us to protect your confidentiality. So we're going to protect that employee. You don't want us as an employer to, reveal to you everything that's happening with this employee, because you expect the same sort of protections as an employee of the organization. And not surprisingly, that is a message that sort of resonates with employees. I get you can't tell me everything, but I just want you to protect me. So tell me how you're going to protect me in this environment. And there are ways to do it. And so you have to think, both ways. It's an and situation, not an or situation when you're trying to address it as an employee.
So before we move on, I just want to give the second code for those who want CLE credit. This is, again, you have to put on your affirmation. Is the second code is LER, Labor and Employment Relations, LER 623. Howard, do you want to proceed with?
If you just go to slide 37, and when I'm moving on, sure we certain things. But I'm glad that we were having this discussion. Though, this is something that we talked about before. It's important to make sure that the process is one that's a two-way street. So 30.
That's the title.
Yeah, you're right. Yeah. So I mean, all these slides, 36, 37, 38, I think they're just meant to highlight. And I think this is where, again, the New York City law, when it first came out, the cooperative dialogue and the fact that you have to memorialize everything, I think a lot of clients of mine, another document we have to fill out, another form. But I think fast forward a few years, I think it's something that ultimately has been helpful because I think it's memorializing, you told us you need this. We could not give you that accommodation. However, we offered you these three accommodations and you're refusing them, or you countered with this. So I think it helps to for employers sometimes they feel like employees ask for an accommodation and that's all they want. They're not willing to, we've offered them 4 different things. And I think the thing for an employer to remember is you have to offer an accommodation, not necessarily the preferred accommodation that the employee wants. So I think that's where, from the employer, there's lots of different ways to accommodate someone. And as long as it's a sufficient accommodation, again, it may not be the one the employee wants, but if it's reasonable and it allows them to perform the job with or without an accommodation, you fulfilled your burden. I've had cases, including one where we ultimately did get summary judgment, where we provided an accommodation. We relocated where someone worked to account for an issue she had commuting, but it wasn't she wanted to be at a different work location. And we said, we can't put you there. But we're going to put you in this other location. And your physician said you can't commute for, over X amount of time. This fits the bill. It's just not where the person wanted to work. And the court agreed that we gave that person a reasonable accommodation. So, again, that's where documentation is key in these type of things, including medical documentation, where, if you offer an accommodation, the employee says, well, that's not going to work. Why won't that work? Being able to see something, because again, HR folks are fantastic, the ones I work with, but they're just like, I'm not a doctor. So being able to see that and kind of help tailoring the accommodation, again, because it may have worked with a person with a similar injury in the past, may not work now. Sure. Yeah. Let's see. Let's go to 52, and then I want to make sure we cover the ethics piece as well.
Which is
52 is the New York City's cooperative, dialogue. Again, since we're all here in New York City, I just wanted to highlight this slide, under the New York City human rights law in terms of the cooperative dialogue, which, is some have said is kind of like the interactive process on steroids.
And this is under the New York City Administrative Code.
Yes. So, the key here in this second bullet point, dialogue. Never say no, or at the beginning of a conversation, think creatively and out of the box, and you have to document. And supervisor should partner with HR as appropriate. And you have to really document, really everything that's happened. We had a meeting on this date, and we offered you this accommodation. You said no, we offered you that. And the law requires an employer that you document all of this. And even at the end of the day, if you are able to reach something, you have to document all of it. And especially if you're going to say no, you have to provide the reason in writing, not just we couldn't give you this accommodation, why we couldn't give you this accommodation. So you have to make sure as an employer, you document all this. And again, I think it's a best practice to do regardless of where your location, but it's something that, you have to be able to, document. So why don't we go to the ethical piece, and then we can circle back at some of these issues under the law. But a lot of it, we've discussed in kind of our conversations.
So I'll talk about this piece, the ethics, and talking about representing people who are suffering from mental health issues. I think comes up a lot, and it can come up outside of this idea of an accommodation, a reasonable accommodation. It can just come up in our representation of our clients in day to day. Like I said, I represent a lot of teachers. Sometimes they're subject to disciplinary proceedings. And I've interacted with a lot of my clients who, I am not a doctor, I am not a psychiatrist, but who appear to me to be suffering from mental health issues. And sometimes they appear to have diminished capacity due to these issues. So what do I do? And this comes up a lot, actually. And I'm always telling myself, you're not a doctor, you're not a psychiatrist, but you have to think back about the ethical considerations. There's the ABA model rule, which we have in the slides. It's 1.14. It's the same. The New York model rules are exactly the same. And it talks about representing a client with diminished capacity. And it talks about it with a lot of humanity, which especially in the comments, which I really appreciated. As you can see up here, the clients with diminished capacity, as far as you reasonably can, you need to maintain a normal client-lawyer relationship with the person. Where it gets messier is what if you can't? What if this person is so severely incapacitated? What do you do then? And the rules talk about that. We can move on to the next slide. If you believe that they're have a diminished capacity, or if they're at risk of physical or financial harm, you can take necessary protective action, including consulting with others that have the ability to take action to protect the client. Even in appropriate cases, seeking the appointment of a guardian ad litem or a conservator. That seems to me to be very extreme. I have never encountered that, but sometimes if you are talking to someone about a possible settlement that they will need to understand, review, and ultimately sign, you may want to, ask them, or sometimes this happens a lot. People will ask, can I have my family member come? Can my partner, or even sometimes I have parents, even though these are also adults, come and sit in and help explain this to me and be someone who's there hearing and listening. That's absolutely acceptable under the rule. Obviously, you'll need to talk to the person. It may, impact your attorney-client relationship, but if that's something that they need and they want, then under the rules, you should certainly do that. And in the comments to the rule, it specifically says, you can consult with family members, talk to people. And so that is an important thing. So the thing that I've struggled with as a practitioner the most is determining the extent of the client's diminished capacity. Can this person sign this settlement agreement? Can this person enter into this contract? And so the rules, it's comment 6 talks about this, and I found this to be really helpful. It says, in determining the extent of the client's diminished capacity, the lawyer should consider and balance factors such as the client's ability to articulate reasoning leading to a decision, variability of state of mind, and the ability to appreciate consequences of a decision, the substantive fairness of a decision, and the consistency of a decision with the known long-term commitments and values of the client. And it also indicates in the comments that in appropriate circumstances, the lawyer may seek guidance from an appropriate diagnostician, which brings us back to the beginning of the DSM and the, does this person have a mental health provider or someone that you can consult and talk to? So just also know that you shouldn't be disclosing this person's condition unless it's a very severe impairment. But know that you can look at the model rule. I found it to be really helpful. And I think about it a lot when I'm trying to represent people who appear to me, and it often is coming up in undiagnosed mental health issues where you can tell. I mean, we've been doing this, if you've been doing this long enough and you're dealing with people, you can tell if someone isn't understanding what you're saying, or is asking the same questions over and over again, or maybe anxious or whatever. And I've also found, and maybe this is wrong, but sometimes this goes hand in hand with substance abuse. I see people that are clearly suffering and then are adding on the substance abuse, which makes it a difficult situation. But look to the model rules and know that they're there to help and to guide.
I will note, because my practice is exclusively representing people with disabilities. So obviously my training on interacting with people with with disabilities and maintaining attorney-client relationships might be far superior to someone that doesn't do this sort of on a daily basis. So when I examine the rule, my focus is much more on this risk of substantial harm. And so for the most part in our office, when we're looking at this, we are very protective of the normal client relationship and the expectation that we're not using bias or stereotype to drive our determination about when we might breach that normal attorney-client relationship. What I have to say about this is that in the legal field, we like to make things a lot more complicated than they need to be a lot of the times. And when interacting with a lawyer, even if you don't have a disability, it can be overwhelming for the client to engage in whatever settlement agreement we've written in a way that is completely not understandable. And so that's another factor to take into consideration. How do I deliver a message so that I can get the consent of the client, that the client is driving the end result? I also really do use observable behavior during this interaction. I have an attorney-client relationship with you. I let the client know that this rule exists, that I'm having trouble interacting with you right now. I'm observing this change in your behavior. Is this a good time to meet? Can we pick a different time to meet? You have the ability to bring somebody into this conversation, but if you do bring this person into the conversation, you may breach the attorney-client protection here. And so confidentiality doesn't exist. What would you like to do? Or, there's definitely times where the client is loud and emotional and not able to engage in a attorney-client relationship. It's okay to stop the conversation and pick another time. So our timetables and the client's timetables may be substantially different. It's, being aware of this world is important, but I do think that making sure you don't forget subsection A, which is that a normal attorney-client relationship is expected, and that under the law, until there's been a determination of incapacity, under the law, that a person with a disability maintains the ability to make decisions about their lives without a lawyer sort of interfering with that ability. And those are important sort of factors. The last thing I'll say is think about consulting attorneys that for a living that represent people with disabilities. When you're an attorney in crisis, and if you're running to this role, you're like, I have these problems. There may be strategies that many of us in the nonprofit world who interact with people with disabilities as clients may be able to share during that period of time that could be very helpful without having to pierce the attorney-client relationship.
Right. And just, if I can say, just emphasize what you've said, it's good for you to say it out loud that just, you can end the meeting. If it
Yep.
seems like someone's not getting it or can't handle it right now, say, that's all right. We're gonna, we'll do this tomorrow or at a time when you can do it. I found that to be obviously extremely helpful.
Yep.
Yes.
So to close out, why don't we go to the other resources?
Sure. So we just listed a few that are sort of helpful. The job accommodation. I'm sorry, that's on the next slide. I'll go to this one. We just listed these as, and this is not the extent to the resources that are out there, but the Department of Labor has quite a lot that they've produced since 2022. I would encourage people to take a look at some of those resources on a federal level. The ADA National Network is another important one. And on the next slide, the Job Accommodation Network was mentioned earlier. And then, it's really important because we did not spend an enormous amount of time on it. The Division of Human Rights and the New York City Human Rights, they have websites themselves. Some of them are much more user-friendly in their presentation than the federal websites are on the ADA. And then the last one I put in there, my organization has some fact sheets. If an employee wants to kind of have some plain language guides on this process, feel free to reach out to our website.
So on behalf of the New York City chapter, I want to thank everyone for attending today. Thank the excellent panelists for their presentation. This program will be being videotaped and will be available on the LERA website. Thank you all. Have a great evening. Thanks. See you in the fall.